hearings. The first one, is there anybody here to talk about the First Place Billiards? I don't see anybody from them or whatever. I thought it'd be fast, so if somebody was here, I'd get to move it out of the way. So, 1200 65th Street, Oliver Lofts. I'd like to hand this over to Vice Chair Koo, and I'll step down because of potential conflict of interest, whatever that language is.
Related to your property or business interests.
Business interests. Thank you.
Yes.
So, Claudia, this is
I'll
yours.
do the staff report. Commissioners and members of the public, this is a continued public hearing pertaining to a reuse and renovation of an existing light industrial building to 50 residential lofts. The Commission reviewed and considered this application at their January meeting, and at that time requested that the applicant revise the plans to fully meet the off-street parking requirement of 63 spaces. Plans call for the renovation and reuse of the old Oliver Rubber Company into a 50-unit, one-bedroom residential loft project. Units would range in size between 810 feet and 1,300 feet. And plans now show that the applicant has provided all the parking on site by incorporating 4 hydraulic parking mechanisms, I believe, into 4 of the spaces, thereby doubling the capacity of those spaces. So the ground floor surface parking equals 56 spaces. The Klaus hydraulic system has been incorporated into 4 spaces for an additional 4 spaces, and then motorcycle and bicycle parking make up the additional 3 spaces for a total of 63. In addition to the parking requirement having been changed on the plans, the applicant also provided more information and analysis regarding the office spaces that you were concerned about at the last meeting. The revised plans now clearly show that these spaces do not meet the Uniform Building Code standards for light, ventilation, or emergency egress. And in addition to that, the applicant has pointed to the fact that they do not include a closet and have been incorporated into an open floor plan, thereby reducing the privacy which is normally found and is appropriate for that expected of a bedroom. The applicant has also indicated on the plans that the covenants, conditions, and restrictions for the project will stipulate that the office is not to be used as a bedroom, and the marketing plan for the project as well will explicitly describe the office use for uses other than as a bedroom. We believe that this would be sufficient to address your concerns, and in addition to that, upon review of these plans with the building inspector, she indicated that a series of restrictions similar were incorporated and were on the plans for the existing loft project on Horton Street. I will note that since the staff report was written, we have received a letter from the DTSC, the Department of Toxic Substance Control. It was in your supplemental packet, which indicates that they would like more soil and groundwater testing of the project site prior to signing off on it as a residential use. Given that we were not able to actually confirm, even though we sent them the Alameda County letter of January 5th, 99, clearing the project for residential use, we have not been able to talk to the person responsible for this area of Emeryville into exactly what their concerns are or how this requirement would be fulfilled. So therefore, we, at this point, request that you amend the condition of approval to specifically also make sure that DTSC clearance is received as well. We have a general clearance in the conditions of approval, but we would name DTSC as a specific agency to receive clarification and clearance from prior to the issuance of a building permit. With that, I would recommend approval of this project, which consists of the following items from you should you wish to move in that direction. First, it would be a resolution adopting the negative declaration for the project. Secondly, a resolution rezoning or recommending that the site and an additional site be rezoned from general industrial to light industrial. then a conditional use permit and design review for the project, which would not be effective until the rezoning process was completed in front of the council, which is expected sometime in late March or early April. With that, I would be glad to address any specific questions you have.
Thank you, Claudia. Do any of the commissioners have a...
Yeah, I have a
clarification?
question. My understanding is that the California State Water Quality Control Board for the San Francisco Bay region was designated as the lead agency for review of the possible hazardous materials on site. And this late coming letter from DTSC doesn't indicate that DTSC has jurisdiction. And I'd like to hear from the applicant or from somebody whether putting a condition on the approval of it. First of all, are we required under the law to condition the approval on the approval of an agency whose jurisdiction I personally don't know is there? And secondly, I'd like to know substantively from the applicant if this is something that's likely to be a terrible delaying burden.
As to the first part of that question, I believe the planning director has attempted to contact the Department of Toxic Controlled Substances to kind of flush out a little bit more what led to this letter, what are the issues behind it. The city has a long-standing relationship with the Department of Toxic Controlled Substances, and as another public agency, whether it's a legal requirement or not, I think it's prudent to at least consider, or at least make an initial, have an initial conversation with this agency before ignoring or making any determination that we don't think they have jurisdiction. I don't know if that conversation has occurred or that correspondence has occurred.
We've traded a couple of voicemail messages. They do have some concerns about how the consultant that was hired by the applicant or the owner characterized some of the existing soil and groundwater contamination as the fault of the property next door at Myers Drum. And their analysis of the Myers Drum site, of which they are the authority and the agency in that case, would seem to direct otherwise. So they just want to go through that, and I have put them in touch with both Susan Hugo of the county, she was the author of that January 5th letter, and obviously have let them know, if they didn't know, that Regional Water Quality Control Board was the agency that we were dealing with, as the agency with authority. I believe this is a quagmire of sorts, but it's not an unworkable one, and we do, through the brownfields effort of the city, do have good working relationships with both of these agencies, and we'll be able to work it through. It's just that it's not at this point. I'd like to move the project forward and have this be the last public hearing, and therefore we could come up with some wording, I believe, that would be acceptable, that we work through this with these agencies to make sure that their concerns and requirements were met.
Yeah, it sounds like they have a reasonable reason for some questions, DTSC.
They indicated that to me via a voicemail, that they're concerned, given the knowledge and analysis that they've done of the Myers Drum site. So that's what this is about.
I have a question of procedures. When is the Department of Toxic notified by the City of Emeryville regarding a proposal? Is there a standard by which the project has to meet? Or is this all projects in the City of Emeryville are referred to the Department of Toxics? Or
No, it's...
This one was selected for some reason?
No, we did not refer this. This was brought to the attention of the DTSC via a process that we've set up called the One-Stop Shop, which is all sites that have been the subject of previous industrial activities are reviewed by these various agencies. I presume in working with these agencies via, in this case, through the Alameda County Department of Health Services and the Regional Water Quality Control Board, that those mechanisms were running and that the requirements that they were, the analysis and requirements that they were required to submit to those agencies for residential use of the property had been completed because we had received the letter from Alameda County dated January the 5th. I'm not quite sure of the exact point that DTSC got involved, except it was recently because we just got this letter on February the 18th.
Well, it says here that it received notice from the Emeryville City Planning Commission.
They must get our agendas. That's how that happened.
Because I am on the Brownsfield committee. That does not include at this time notices of current projects in the one-stop shop.
I will certainly ask the person at DTSC how they were notified. I did not do it as a matter of course.
I'm on the group dealing with Sherwin-Williams, which includes the Department of Toxics and the Regional Quality Control Board and several other Regional Air Quality Control Board and the and if an agency has the lead role, as the Regional Water Quality Control Board did on this site, then any other agency is loath to get in and sort of muddy the waters. This is an unusual letter. So I think that the extent that we need to deal with this is to hand it to the applicant. I don't think we want to put anything in our conditions of approval other than notifying the applicant that this letter has been received.
The applicant has been notified.
If I recall correctly, we had a concern with what was it, the Costarella, the 6 units that went on to the plating site.
Yes.
And we actually went over and above what was required because we were concerned about the health of the residents. So I'm not so sure that we're going too far afoot by listening to DTSC, particularly because of the relationship we have with them. I don't think we can be too careful in terms of residential use on toxic.
Well, you are rezoning, you are recommending rezoning of this site specifically for residential use.
Mm-hmm.
I would tend to agree, Commissioner Lutz. You therefore have to make sure this is a legislative action. This is not just a use permit. You're basically redesignating the property so that it would be appropriate for residential use.
Mm-hmm.
You're also relying on a team of scientists and biologists and engineers that is part of the lead agency, that have done the homework, that have done the investigation, and are not just going off of, have investigated the toxic plumes that are adjacent to the site, and have made a determination that this site is okay for this use. Now you're going to disregard you're going to disregard that determination and go out searching for another determination?
I do not have I am not sure at this time that Regional Water Quality or the county did have all the information that DTSC may have regarding the Myers Jump site. I don't have that confirmed.
Well, they probably didn't.
I would concur that under the law there's a great deal of deference given to the lead agency, and that the very fact that this letter was sent, I would argue, cuts the other way, that because I don't think this happens that often, that it should give us pause.
We're not also holding up the entitlements of this. We're making sure that we have clearances and the clearances we need from the agencies that we need it from prior to the issuance of a building permit.
Right.
So have you added a condition here that, is there language someplace?
No, these are the original conditions we were going
Oh,
to...
so you're proposing a condition that says something like, this approval will not become effective until satisfactory resolution of the questions raised by the DTSC letter to the satisfaction of the planning director, or something like that.
And it would be contained in, on page 4 in subject area 3, which basically deals with the Alameda County Healthcare Services letter, and we would add either onto that condition or draft a separate condition to that effect, Commissioner Getz.
Okay,
yes.
what I would like to see, the language that I would like to see in that additional condition would be that it was you as planning director who had the authority to either approve or continue to delay the approval of this project based on your information from and with DTSC.
Okay.
Do we have any other clarifications from the commissioners? None? Would the applicant like to make some comments and make a case?
Oh, I do. I'm sorry. I have one question. There are two areas of the conditions of approval that are in italics, and they relate to in lieu fee for parking.
I can go over that.
Just what does the italics mean, and what's intended here?
This was my last shot at
Isn't the
making
staff
some-
report or the conditions?
This
The
is
conditions
the
of
conditions. However, it's addressed in the staff report. It was clear to me in running through the revised plans from the applicant that they had addressed your direction of the January 28th meeting. There were now sufficient parking spaces on site to meet the parking requirements. However, I gave one last shot to the thought of an in lieu fee being a compliance method for this particular application, because there would be 2.5 or 3 spaces in question that would be available for an in lieu fee compliance method, which would be approximately $21,000 to the city, or to play Mr. Klaus $12,000 to $15,000 per space to have those spaces be on site. I wasn't quite sure how well or how much they would be used. I've never worked with a system like this, so I don't know how easy it is to use. But certainly the letter of the law has been met with regard to the parking spaces now being available on site. However, what's the best long-term use of those funds that need to be devoted to putting the parking there, and are they better spent through the provision of parking for a private system that may or may not be used, or the longer-term benefit of devoting those resources to a public parking fund for the city? So that is my last spiel. I'm fairly ambivalent about it, but I would like to bring that up as a policy issue.
Is this the time to talk about that, or should we wait?
I think we should wait. Okay.
Unless you want to wait and hear.
Let's hear the comments. I'm sorry. Did you make sure that you sign in?
My name is Nicholas Harlambides. I'm the architect as well as the developer of the project. Regarding the DTSC, we believe that that's a non-issue. We feel that they have been left out of the loop, and as soon as, and we're taking steps to bring them back. We're having meeting set next Monday or Tuesday, and as soon as they find out the amount of work we have done, I believe they will come online in terms of accepting the letter from the county health department. And I also have the owner's representative here who can talk to you and in more detail as to all the efforts we have taken and why we feel that somehow when Barbara Cook from DTSC says no sample data is available from the site, that's not the case. They just haven't been exposed to that data. And as soon as they find out, I think we won't have any objections from their department. In terms of the in lieu fees, I would respectfully request that the developer be given the option, if you so decide to give us that option of either paying the city, and I think that's a good idea, but I think we would like to have the option of either installing the cloud system, which we believe it's going to be more closer to $8,000 to $9,000 per space, as opposed to $12,000 to $15,000 per space. And we would like to have that option of either installing that or paying the city in lieu fees. I don't have anything else other than I'm open for questions.
Thank you.
Thank you very much for your very thorough and detailed analysis of the definitions of the various rooms that are not bedrooms. It totally satisfied me.
Thank you.
Do we have any comments from the public on this project?
Every T and dotted every I.
None? Okay, let's talk about it.
Public hearing.
Public hearing is closed. Thanks.
He forgot to open it, but he's closed.
I'm learning.
Sorry. He opened it.
I can't go for the in lieu fees. I think the neighborhood is more congested than the parking surveys that, show. I believe that the neighborhood is going to get more congested. I believe that when Liquid Sugars and Myers Drum and George Martin properties change use, it's going to be terrible congestion for parking in that neighborhood. And I think we'll get a lot of complaints, and we'll deserve them if we approve in lieu fees.
I agree with that.
I'll agree for that and another reason. It seems the reason being presented now is that the cost, that the in lieu fees are less than the lifts, and I don't think that's a valid reason. It should be a good idea on its own merit, not on a cost analysis.
Since we've already given one developer, I think, 12 spaces on the street for in lieu fees, something like that. I don't have too much opposition to 4 more for this space.
Yeah, I sort of agree with where Andy's coming from. I think that we're going to really get significant reuse in that area, and I think we need to. The problem, I guess, the problem that we're continually face is that the in lieu fee. The idea, I believe, in the in lieu fee was to get enough critical mass so we could start developing some parking, some parking areas, and 4 spaces, I guess, may not be critical mass in this area. So, anyway, I'd sort of be interested. I guess the one question I do have is, I do recall the issue of the way we were having the egress and entrance because of the previous design of these systems, and I guess that's all been addressed and cleaned up.
It wasn't the previous design of the systems, it was the fact that those systems are becoming more widely used, and there is a process to go through, an approval process to go through to make sure that they're approved, or a UL listing, the equivalent of an underwriting testing lab, and that's nearly completed at this point, and we would be able to do that without any problem. We've been doing that in a parallel track as requested by Commissioner Getz at the December meeting. So we've gathered information from other cities who are using them and pretty much are mimicking their process, whereby these things were approved by an independent testing lab.
By saying that, it raises the question of, are we approving a system or a concept here? I thought we were approving a concept until you said that. Now it
We're
sounds
approving
like
a system.
we are.
It is the Klaus system. So we're testing,
Okay.
and they have indicated that they will be using a specific hydraulic lift system in each one of those 4 spaces. And the planning department has been working on approving that so that it meets the building code requirements for such systems.
Okay. That, of course, does not shut the door for other systems, for other applicants in the future.
Absolutely
to
not,
make
or
that
even
clear.
this one. I think in the conditions of approval, you can say a hydraulic lift system such as the Klaus system or an equivalent as
Simple,
approved
yeah.
by the building department.
That would be good. That's a good improvement. Yeah, no endorsements here.
Commissioner Germain, do you have any comments?
In lieu fee is good when it's impossible to achieve parking for the site, but obviously it's possible here. So I'm a fan of the in lieu fee when it's impossible to achieve the parking, but obviously they made it possible.
Do we have any other comments on other general ideas? It seems like we're pretty much in conformance here. Do we want to go through the actual documents?
We've been through them a couple times. Unless there's, again,
Under the conditions of approval, we want to take out C3 as an option.
yeah, we want to take out the italics ones. We want to add the generic hydraulic system.
Right, which I've done under, so I've taken out the italics under 2B, and I've added using a hydraulic lift system such as the Klaus system or an equivalent as approved by the building department for up to 4 spaces. That's how the applicant is meeting their requirement. And then in addition to that, I've added condition 3E regarding the DTSC letter, which reads as follows.
Something along the lines that evidence shall be provided that the concerns raised in the letter from DTSC dated February 18th, 1999 have been addressed as determined by the planning director.
And that's how we would modify from what you have in front of you.
Move
Okay.
approval.
No, I have a couple, sorry. Under 2A, public safety and parking requirements, final building permit plan shall include all special security measures. What are those?
I think we meant to say standard security
Yes.
measures.
Okay.
Thank you.
And item under 6, construction provisions. We came up with the Chiron issue, something I thought was
I know.
pretty good, and that was having a sign posted to where people can call a construction manager or something if there was a problem.
So you want me to,
Well, I'm just opening that up. Is that something that's appropriate here or not?
I'm trying to think about the nearest residence. It's
Okay.
the lap pool, the nearest resident would be the lap pool live-work unit,
which isn't built yet,
which isn't built yet,
it's not occupied yet.
right? And the gambrel roof house immediate to the south.
Okay. I am just raising that. If it's not an issue, it's not an issue.
So is there consensus that that's needed or not? Okay.
Okay, that's all I have.
So the first order of action would be to adopt resolution number ND 99-1, which
So
is
moved.
okay. I guess I'll call for a vote. Commissioner Koo?
Aye.
Commissioner Owens?
Aye.
Commissioner Germain?
Aye.
Commissioner Balangero? Commissioner Getz?
All right.
And Commissioner Lutz.
Aye.
And then the second resolution would be recommending that rezoning from IG to IL to the City Council. And that the additional property has been incorporated, which was missing last time, so we've revised that resolution.
Second.
Okay, Commissioner Koo?
Aye.
Commissioner Owens? Commissioner Germain? Commissioner Balangero?
Aye.
Commissioner Lutz?
Aye.
Excuse me, and Commissioner Getz.
Abstain.
Okay. And then the third resolution would be the approval document of both the design review and the conditional use permit for the project as amended by you tonight. Okay.
Second.
Commissioner Koo?
Aye.
Commissioner, I'm losing it, Owens?
Aye.
Commissioner Germain?
Aye.
Commissioner Balangero?
Aye.
Commissioner Getz?
Aye.
And Commissioner Lutz?
Aye.
Okay.
Congratulations. After 3 meetings. And I bring this back to Chair Mooney.
We need a,
No, the first one was
Chair Mooney, we need just a couple minutes for the plan change.